Mr. Norcross, for 5 minutes.
Thank you, Chairman. Common law to 1935, when the NLRA was passed. From 1935 to 1984, 46 years, working off the same decision, getting decisions from the board, clarifying where it was. Then we had 1984 to 2015, only 31 years. And here we are from 2015 to 2017, or as I call it, back to the future. Because what has happened is we went back to where we were for 46 years of decisions. 46 years. 800,000 franchisees, not one has been considered a joint employer. So I listened to the testimony. I'm trying to make sense. How is it that we can work together to address the issues that we're hearing from you? And the first thing that comes to mind is, Mr. McDonald, you mentioned that the franchisees, or the joint employer decision is hurting the construction industry. How would you reflect on that in the last 2 years, companies have grown, those who are starting? There's an increase of construction companies. Isn't that the exact opposite of what you suggested?
Well, it's the indecision that's going to put an end to it. We're only seeing an increase.
Well, you mentioned that this would keep people from going into business.
Yes, sir, and it will keep people.
But it increased.
Would you like for me to answer the question?
No,
the
but
answer to the question is that we went through an extreme period of negative growth in the construction industry in 08, 09, and 10. And we've seen a rebirth of housing starts. Housing starts have almost doubled in that period of time, and that's what it is, a simple supply and demand issue. I will also say that the protection of workers and labor in our industry is really based on supply and demand. I will tell you right now, because of the shortage of labor we're having, no one's going to treat an employee poorly.
It's my time. I like to keep a narrow focus of what I was asking you, because the employee is not going to be impacted by the joint decision whether or not he's going to go to work for somebody, and that's the problem that we're having. The fact of the matter is that, particularly in construction, job site safety, it's everybody working together. You're not going to throw that on another employee. That's where all the liability comes in. And that's, quite frankly, the reason why the deaths on the job has been decreasing, because everybody works together. I just want to make sure that when we look at what's going on here, instead of going back to the decisions of 46 years, we're going all the way back beyond what it used to be. So the idea of having precedents that and predictability, you're going beyond that. And I just want to follow up with my last question. When I look at AT&T, now the retail stores, almost 60% of their stores are operated by one of two very, very large subcontractors, completely contradicting what you're telling us today. Mr. Rubin, I was wondering if you could talk about, in a broad sense, the different tactics that are used to erode the employer's obligations to employees and how they might vary depending on the industry.
Varies depending on the industry and the creativity of the dominant company. There are lots of ways to do it. The AT&T example is one. We know through the communication workers how they're able to structure the relationships so that they maintain their control.
Because in the construction industry, the fact of the matter is joint employer is not happening all that often.
Very rarely. Of the 9,036 cases identified by Mr. Fassman that were filed under the FLSA in that 1 year, I bet no more than 2 or 3 included a joint employer allegation. It is a rarely advanced theory, but a critically important theory, which is why we need to preserve it. It's not just that the law went through a 46-year period. Under the Fair Labor Standards Act, this would change law going back 81 years since the FLSA was enacted. Even with the NLRA, this notion of direct and immediate didn't come into play until 2002 in the Airborne Express footnote. So in fact, it's not even 1984. The standard that was rejected in Browning-Ferris was in fact a 2002 standard. It's a period of only 13 years.
Thank you. we need to sit down and work together because these facts are completely opposite of each other. We don't need to go all the way back. We need to sit down and have a reasonable discussion, work this out. I yield back.
Thank you, Mr. Norcross.